Good morning.
Good morning.
You could hear me and see me okay? I'm on
I
a new rig here.
I can,
Okay.
even on Friday.
Yeah, well, it's a good day though. I
Well,
heard
I think I've decided that with recent events, every day you're vertical, it's probably a good day.
that's right.
Good morning, Mr. Lee.
Good morning, Judge. How are you?
I'm well. How about yourself?
Good.
I was just trying to look through the exhibits. Did I send you 7 and 8?
Yes, ma'am.
Okay. Do I owe you any exhibits?
I don't believe so.
Awesome. We have a few exhibits in this case.
Yes, ma'am.
Are we over 100?
I don't think so.
Think we're probably close.
Yeah, I think you're right.
Okay, it looks like we're still waiting for a few more people.
Mr. McMillan? Mr. McMillan,
Yes, sir.
who are you with and who do you represent?
OPL,
And the firm you're with?
O'Melveny and Myers.
Are you out of LA?
No, Austin.
And can you give me your full name?
Sure, it's Michael, Michael, McMillan, McMillin.
Thank you, Mr. McMillan.
You're welcome.
Well, before we go on the record, has anybody got any procedural matters that we need to deal with? And especially if anybody thinks that we have an outstanding exhibit other than hearing exhibit 5 and its supplement. If we have any other exhibits that I might not have ruled upon entering or not. Especially if it's your exhibit, please let me know. Like I say, I think at this point we're pretty close to 100 because I think SPS had over 50, and then when you include everybody else's and then the commission exhibits.
Your Honor, I'll double check my notes, but I think the only one I know of that we have hanging out there is the supplement to bench 5.
Okay.
And also in process, I had in my notes that obviously we're starting with Mr. D'Ascendis in the lineup for today. Was Mr. Grant before or after the staff witnesses?
I think I had Mr. Grant after Mr. Gorman.
Okay. Thank you.
Thank you.
So, ma'am, this is Joan. Will Mr. Gorman be up after Mr. D'Ascendis?
Yes, ma'am. That's what I just said.
Great. Thank you, ma'am.
and parties can be thinking about whether or not they want to, they think it's necessary and or helpful to file any post-hearing writings, and they can think about and coordinate with each other that perhaps that might be a joint filing or not. You could be thinking about when you might want to do that. I mean, I know people have other things to do, and especially for those of you who might be participating in the upcoming P&M hearing or other hearings that the commission has. So anyway, you all can let me know at the close of our hearing, which I believe is going to be today.
Ma'am.
Okay.
This is Joan Drake again. I was going to put in a plea for us to end today because Monday morning is the rescheduled workshop in the procurement and IRP rulemaking. Just wanted to make you aware of this, and I think some of us have already committed to being in that workshop. Just
I appreciate that. Okay, before we go on the record, let me just make a phone call.
Mr. McMillan,
Yes, sir.
can you tell me your email address?
Yes, it's M McMillan, McMillin @OMM.com.
Thank you, sir.
Good morning.
You're on mute, Judge.
Thank you, Mr. Lee. Some people might prefer it if I stayed on mute, but I think for the record, probably it's a good idea. Good morning to everyone. I believe we are now assembled, and we are back on our record and ready to continue with the evidentiary portion of the case. And I believe we have recalled you, Mr. SPS witness D'Ascendis. And good morning, sir. And you're still on. And I believe Commissioner Hall had some questions for you. Commissioner Hall?
Thank you, Madam Hearing Examiner. Good morning, Mr. D'Ascendis. How are you?
Doing well. How are you doing, Commissioner?
Not bad for a Friday.
Yeah.
I used to say in a previous job I had with the U.S. Navy, only 2 more working days till Monday. Okay, Mr. D'Ascendis, I'll get started. And I don't have many questions. I don't think this will take long. On page 89 of your rebuttal testimony, you take issue with the support for witness Cahill's range of 5% to 8% for market risk premium specifically because it was published in 2006. Is that correct?
Yes, ma'am.
Yeah, the citation that you give in support of analyst growth rate superiority for the DCF analysis is a publication from 1982, is it not?
It is, but there's a little difference between that. So over time, I guess, when you're talking about equity risk premiums and things like that, it changes over time, and I think most of the witnesses would agree to that. When you're talking about specific measures like growth and things like that in a DCF model, it's just it's a preferred and superior method, and that type of academic literature would still hold today, and as far as I could tell, it hasn't been rebutted in the academic literature. So now there will be some articles saying that about EPS growth rates and some limitations, but all in all, the academic literatures support using EPS growth rates, projected EPS growth rates, and I think Mr. Kale, Mr. Walters, and Mr. Tupler all did in their analyses.
Okay. Do you disagree with witness Garrett's assertion that short-term analyst growth rates should not be used in a long-term DCF study, and why or why not?
Short-term meaning what? Like
1 to 3 years.
So I don't agree, and in general, in general, this case, there's a lot of disagreement between the parties, and ultimately, we came up with a settlement, and those differences are reflected in the black box portion. But in general, I take the position of Mr. Kale. Mr. Kale said it well yesterday. 3 to 5 year projected EPS growth rates are not short-term growth rates. I would say that, like we just said in the last answer, it is well defended in academic literature that EPS growth rates.
I'm sorry, it's well defended and
Say one more. And supported in the academic literature that EPS, or earnings per share growth rates, are the superior measure in a DCF model, and was used by every other party in this proceeding besides Mr. Garrett.
In your rebuttal testimony, you argue that the Duff and Phelps approach to estimating the market risk premium is opaque, not transparent. Is that one reason to discount the Duff and Phelps approach?
Yes, and I don't remember where that would be. I think it's in Mr. Garrett's section. But yes, so Duff and Phelps, in general, they produce a number of equity risk premiums in their books, and one would be the historical average, arithmetic mean average equity risk premium. Mm-hmm. One would be the build-up method, and those methods are easily reproduced. The Duff and Phelps ERP, which is equity risk premium, is not easily reproducible. They do not give specific measures or anything that you can look at and reproduce. So that's why I think it's opaque and shouldn't be relied upon.
Okay. Well, in regard to your analyst projections of growth that are used as inputs in your DCF analysis, you note that we do not have information as to how different criteria are weighted. Is that correct?
I agree with that, yeah.
Would that qualify as opaque?
Not exactly, because there are certain metrics that they look at. They during earnings calls, the analysts will ask questions of the companies based on their operations and say rate cases or something like that. So you know where their minds are well, I can't characterize where their minds are, but you could see their areas of focus and what is driving their growth rates. And usually, say for value line growth rates, they'll have a little explanation on what they were weighing in their report. So I wouldn't say that they're as opaque as, say, the Duff and Phelps ERP projections.
On page 138 of your testimony, you note that comparable credit ratings does not mean equal credit ratings. Is it your position that the commission should adjust the ROE upward to create strict parity with the proxy group's credit ratings?
I do, and I'll tell you why. And it's more when you're looking at the proxy group, you can't have it's impossible to have a proxy group that is equal in risk to the company. And an analyst should look at the relative risk measures between the company and the proxy group to see whether or not there are or are not reason to make adjustments. And through my analyses, I had 3 minor adjustments, and one is flotation cost, which is not specifically a relative risk adjustment, but it's just the cost of floating the equity or issuing the equity.
Do you think it's the business of the commission to make sure that the companies under its jurisdiction, excuse me, have equal credit ratings to proxy groups?
I think that the commission should set the return at levels that are comparable to other investments in other jurisdictions. So if you're looking at, say, or not in other jurisdictions, but in comparable risk, I'm sorry. And if you're looking at the proxy group, which is the only data that we have, you would want to set that level at that risk. And any way to, say, put apart the target company to the proxy group company, you should, and I don't want to tell you what to do, but one should recognize the difference in risk between the group, and it could be lower risk. If SBS had a higher credit risk adjustment than the proxy group company, I would have proposed a negative adjustment, and I have in other jurisdictions for other cases. But once you get there and you see that it's a little bit different one way or the other, you should reflect that difference in risk.
In what?
In the RO. Oh, I'm sorry. Say it again.
I just didn't hear your last word. You should reflect that difference in what?
Oh, in the ROE, I stopped short.
Yeah. Okay.
Thank you for letting me finish.
Yeah. Let's see here. On page 151 of your rebuttal testimony, lines 13 through 15, you state, and I'm quoting, "In view of the legal standards cited by me and Mr. Garrett and treatises on regulation, likening regulation of utilities and the competitive market, it is clear that allowed returns and investor required returns are also equal." So does this mean that investor required returns are equal to whatever the commission allows for?
It's the same as it's more when you're looking at the legal standard and commissions in the legal standards, and I'm not a lawyer, but my interpretation, my lay interpretation is that the commission should set the ROE at the cost of equity or the required return. And since the required return would end up being the authorized returns, they're equal.
Thank you.
Well,
Sure.
Mr. Diascendis, if that's the case, then what do you think the commission should set the ROE as a result of the stipulation?
Well, the ROE as a result of the stipulation is just reflected in the Hale and Sagamore, and then the differences between the positions should are reflected in that black box disallowance. So I think that there shouldn't be an ROE set on anything besides those two projects and the statement that Mr. Garrett and Mr. Nelson went through yesterday. The consolidation or I don't remember, but I think it was Exhibit D yesterday and attached to the settlement.
Could you, Madam Hearing Examiner, did you have another question? Follow on? That's
No,
fine.
ma'am.
Okay.
No, ma'am. Thank you.
Mhm.
No, please go ahead, Commissioner Hall.
I am. Well, let me ask you this. Why are the rate case expenses so high, given that there's a stipulation?
I don't know if that's I don't know. I just kind of I don't know. I'm not the person that you should ask. But I mean, in general, it went through, and I don't know what the rate case expenses through, but we went pretty close all the way through, close to hearing. So, and then these are hearing. So, it's not surprising. In my experience, it feels like a fully litigated case, even though it's a settlement.
We seem to be resolving. Would you say we're resolving an issue? Why are we resolving an issue related to case expenses for a previous rate case?
I don't have to answer that question. I'm sorry, Commissioner.
Do you think that's retroactive rate making?
I don't know enough about the subject.
Okay.
I'm sorry.
Commissioner Hall,
Fine.
Hearing Examiner, I'm going to object. We're way
Sorry,
outside the
I
scope
don't-
of Mr.
can you say-
Deason.
I'm sorry, can you start your objection again?
Sorry, Will Du Bois for SPS. Commissioner Hall, Hearing
All right, I
Examiner,
withdraw the
we are
question.
completely outside the scope of Mr. Diascendis's testimony at all in this case.
It's fine, I'll withdraw the question. Originally, using your various methodologies, you calculated a cost of equity for SPS of 12.77% using DCF, 12.57% using our risk premium method, and 11.79% using the CAPM method, correct?
Where are you pointing to, my direct or my rebuttal?
You're direct.
Okay, let me get there. I think you're referencing my non-regulated group results. Just is that correct? So
Say that again.
are you referencing my non-regulated group results? Because it sounds more familiar there. I'm just going to turn to the page.
Well, I'll just get to my question.
Sure.
Why did you recommend an ROE of 10.35%? That's well below your cost of equity estimates in your studies, when an ROE below the cost of equity would clearly contravene the Hope and Bluefield standards.
So I could walk you through the way I calculated my range and then my ultimate result or my ultimate recommendation if you'd like.
Well, I guess I'm asking why, not how.
Well, I'll show you how and why it's within my range of results and things like that. So if you turn to, and you might want to put this up, Miss Hearing Examiner, Schedule 1, page 1 of 1 of attachment DWD1. And I'll wait.
What, do you have your,
Oh, you want,
what
so
number your exhibit?
yes, it's Exhibit 8. I don't know what PDF page it would be if it was if it's a combined,
Okay,
if it's a combined set, it's probably
and it's schedule,
1, page 1.
okay, schedule 2. Okay. There you go.
I appreciate it. Thank you.
Uh-huh.
So if you look at my 4 model results, you have a range between 9.06 and 12.48%. So, and then I have my initial range before adjustment of 9.92% to 10.96%. Now, the way I derived that range, because I think you and Mr. Kale had some conversations about this yesterday, the top end of my range is the average of the 4 results. The bottom end of my range is the average of the average, which is 1096, and the 906, which is the DCF rate. I then
Which is the DCF rate, you say?
yeah,
Yeah.
so the average of the 1096, which is the average of all 4 results, and then the average of the average and the DCF comprises the low end of my range. So if you take 1096, you add 906, and you divide it by 2, you get 992. Okay, so the DCF in general makes up about over half of my weighted result here on the bottom end of the range. And then when I apply the adders, which I discuss in my testimony, I get to that range of 1033 to 1137. And then there's my 1035 right there within the range. So it is within the range of my results. I weight the DCF heavier than I usually do based on uncertainty through COVID. And so I do believe that it would pass the requirements of Hope and Bluefield because it's based on market rates that I derived during through my analyses. And I think, yeah, and that's what I said was shown in footnote 5. And I appreciate you continuing to scroll down.
Commissioner?
Yeah, I'm done. Thank you, Mr. DeSantis, on that question. I'm done with that question.
Thank
I
you.
just got one more question. Under the stipulation, SPS would have a 90-day grace period for maintaining an equity ratio greater than 55%, correct?
I think that's right.
How long must SBS maintain an equity ratio within that specified range before it can deviate into that 90-day grace period again?
That would be a question for, I would assume Miss Martin, but I wouldn't know for sure. I'm sorry, I couldn't answer the question.
Okay, Madam Chair, I have no more questions for this witness.
Very
Thank
well.
you. Thank you very much, Mr. Diasendis. Appreciate
Thank you.
it.
Have a good weekend. Hopefully,
you too.
hopefully you don't have 2 working days until Monday.
I wish I didn't. Thank you.
Thank you, Commissioner Hall. Any follow-up, Mr. Dubois?
No, thank you, Your Honor.
Any questions from anyone else? Hearing none. Thank you for coming back, Mr. Diasendis. You are excused, sir.
Thank you very much. Have a good weekend, guys.
Yeah,
Thank you. The
too.
same,
Yeah.
same to you. I believe, just so I don't forget, we have under consideration SPS's hearing bench request number 5. Which was filed on the 28th. And then I believe the supplemental response was filed on the 29th. And I'm going to consider them as one complete response to bench request, hearing bench request number 5. Is there any objection to them being admitted? Hearing no objection, the complete response to bench request number 5 is admitted. All right, I believe we have another witness. Good morning, Mr. Gorman.
Good morning. Apologize
Drake?
for the mix-up yesterday.
Not a problem. Ms. Drake, this is your witness?
Yes, ma'am. This is my witness. I believe his testimonies have already been admitted, but I would remind the hearing examiner and commissioners, if they're on, that Mr. Gorman did have 2 testimonies of his own, and then he adopted, with Your Honor's permission, the 3 testimonies of Ms. Alderson.
Yes, very well. Mr. Lee, could you swear Mr. Gorman in, please?
Mr. Gorman, would you raise your right hand, please?
Yes, sir.
You solemnly swear the testimony you're about to give to the matter not pending should be the truth, the whole truth, and nothing but the truth.
I do.
Thank you, sir.
Thank you.
Mr. Gorman, I just have a few questions of your testimony and of Ms. Alderson's testimony. And I guess I want to find out from you, because this is not the first time you've been before the commission, is it?
It is not.
So welcome back.
Thank you.
And I'd like to know, based on your knowledge and experience, and specifically before the New Mexico Public Regulation Commission, on page 24 of your direct testimony, you're referencing SPS's direct case and talking about the credit metrics. And on line 4, your answer begins on line 4, page 24. And you say SPS's cash coverages of credit metrics will improve over time without an unjustified or unnecessary increase and SPS's authorized rate of return and or depreciation / amortization rates in this proceeding. That's your testimony, sir.
Yes, it is.
And do you recall, there's been an assertion that in, at least in recent rate cases of other electric IOUs here in New Mexico, but I would extend your knowledge to any rate cases in New Mexico, whether or not the IOU has actually put that issue in play before.
Well, it's not always a major issue in a rate case like it is in this one, but generally in rate cases where I address rate of return, I do look at credit metric calculations based on the rate making calculus. The rate of return, the rate base, related cash flow implicit in the utilities cost of service to ensure that those cash flows are adequate to support the utilities bond rating, in which case I argue that my overall rate of return represents both fair compensation, but also maintains the utilities financial integrity and supports its credit rating. So it is an analysis that I typically do for utilities whenever I address rate of return in total or rate of return in part, like I have in this case, to ensure that the rate of return being recommended meets the Hope and Bluefield standard, which is just and reasonable rates where customers pay no more than what is necessary to provide fair compensation, maintain the utility's financial integrity, and support its bond rating.
It just seems as if there's more of a focus in this case. I can't recall it being made an issue in the past, and obviously it is an issue because SPS has one or more witnesses, including Ms. Martin, whose testimony I'm assuming you reviewed, who basically is stressing the importance of the credit metrics and commission decision making and the effect, the claimed effect that SPS says is out there with the bond rating agencies. Isn't that true?
It is true. And I think because of the unique circumstances of this utility, the credit metrics is an important issue in this case. We went through quite a bit of testimony the last couple of days about a rate-making capital structure and an economic capital structure. This utility is somewhat unique in that it does have significant off-balance sheet obligations, which necessitates an economic capital structure that will maintain that bond rating. And then from that, a rate-making capital structure has a somewhat higher common equity ratio that aligns with the economic capital structure that is needed for rate-making purposes. My analysis went into that detail to ensure that the overall rate of return was no more expensive than necessary to support this utility's bond rating. Went also with the objective of setting rates in a manner that provides economic signals to the utility to manage their future cost of service in a way that makes this utility as competitive the utility as possible. And from that standpoint, my capital structure supports the utility's ability to either choose utility investment in infrastructure that would be included in rate base, or to contract for infrastructure investment through purchase power agreements while still maintaining its financial integrity, and choosing between those two alternatives in a way that will maintain their financial integrity and ensure that their cost of service is as competitive as possible. So it is more detailed and more complex, largely because this utility has chosen to use purchase power agreements in a manner that does benefit customers, because those agreements I haven't reviewed this for this case, but presumably were shown to be more cost effective than utility investments in similar infrastructure. So my analysis was cognizant of the need for a competitive cost structure and to recognize utilities' on-balance sheet financial obligations and their off-balance sheet financial obligations in a way that allows this utility to maintain as cost of service that is as reasonable and offer rate structures that are as competitive as possible.
Well, in just in terms of the choice that you just testified that the utility made with regard to the PPAs, if you've been listening to the testimony, I mean, the chairman has asked several questions on the differences between how that the PPAs are treated, not just by the bond rating agencies and including them as debt, but also the way that the fuel is recovered in a manner that's different, and the implications to ratepayers of that. Have you heard that testimony?
I have, yes.
And so sort of how, based on what you said, how, do you feel like that, that there needs to be some type of justification for that treatment?
Well, I think there is. Credit rating agencies understand how purchase power costs are recovered and what regulatory mechanisms are used to allow for recovery of those costs. To the extent they are separated and allow for a rider recovery, that improves the likelihood the utility will fully recover those costs from customers. And as the utility recovers those costs from customers, they're then able to improve the likelihood that they can meet their financial obligations under those purchase power contractual commitments. The credit rating agencies look at that cost recovery structure, and based on that, they, as Mr. Kale indicated yesterday, they assign a risk factor to those capacity components of those PPA obligations in assessing their debt-like nature. From a debt-like nature, the question is if the third-party PPA supplier fails to provide power under the contract, but the utility is still obligated to make some capacity payment to that supplier, then that contractual structure has some debt-like characteristics to it, because the utility in that instance would be obligated to make some PPA capacity payments, but then would also have to go to the market to buy replacement capacity. That'd be similar to a utility-owned generating facility that was forced out of service. In that situation, the utility would continue to have to make their debt service payments on that facility, but may have to go to the market to buy replacement power. In that instance, there is some financial risk to the utility in terms of whether or not they can recover the replacement power cost and still recover the full debt service cost and earn its rate of return in the provisions of service. So there are truly some debt-like natures to purchase power agreements, which are similar to the utility-owned generating facilities. And the same can be made for certain leasing structures that the utility enters into as a component of the resources they have available to provide service to their customers. Those operating leases, in some cases capital leases, are also part of the debt evaluations credit analysts look at in assigning the overall financial obligations of the utility.
And with regard to your direct testimony regarding beginning on page 35, regarding your adjustment to the rate making capital structure.
Right.
That changed to from the direct to your stipulation testimony, correct?
Well, in the stipulation testimony, the stipulation for the specific terms of the overall rate of return was based on the company's capital structure, but it included a black box adjustment to the revenue requirement. So that there was a negotiation in the development of the revenue requirement. So it's a matter of interpretation of the settlement revenue requirement as to whether or not we feel that the overall rate of return that's implied by the settlement revenue requirement represented a concession from what we recommended in testimony.
And you're comfortable, or are you comfortable with basically the I guess the explanation that the commission seems to be getting, that we agreed on a revenue increase I guess of $62,423,334. And
I'm sorry, 62,423.
62,423,334. Is that correct, Mr. Gorman? I'm looking at the page 7 of Exhibit D.
Yes, $62,423,334. Yes.
And so kind of the explanation seems to be it's like, okay, commission, here is what we agreed to resolve this case. And there's some other specifics, but I'm just focusing on this right now. We agreed to this, and here's, if you looked at it a certain way. So if you go back to page 6, and if we looked at it where we plug in a 4.31 long-term cost of debt, a 9.35% cost of equity. And for the cap structure, we have a 45.28% long-term cost of debt and a 54.72 ratio of common equity. And that all results in a weighted average cost of capital of 7.07. And so if you use all those numbers, or it seems like the parties are saying, let's pretend that those are the real numbers, then you can come up with the $62,423,334 that we've all agreed that SPS should recover. Is that right, Mr. Gorman?
Well, it is right. I mean, the bottom line revenue increase in the adjustment to rates align with the findings by all the parties of what a reasonable change in rates would be in this case. Each of the parties can derive the revenue requirement based on what they think would be appropriate cost of service components. And after everybody made their independent evaluation of that, all parties reached the same conclusion that the $62.4 million increase in revenue was reasonable. We don't all agree on what the overall rate of return should be. We didn't all agree on what the operating expense, even some of the rate-based components were. But at the end, we all agreed that the revenue increase was reasonable. We also all agreed on the appropriate compromise and cost to service spread of that revenue increase across rate classes. And ultimately the development of rates that would produce the revenue requirement for each of those rate classes. That was all part of a very comprehensive negotiations across all the parties in this case to develop both the revenue requirement, the spread across the rate classes, and the development of rates within each rate class.
And I'm not trying to trivialize the party settlement process, Mr. Gorman, or the endeavors that the parties engaged in to develop their direct or rebuttal testimonies. All I'm asking is that utilizing basic rate making principles, isn't the commission and aren't ratepayers entitled to some basic numbers that characterize and define the utility business structure as it relates to the ratepayers? And aren't those, wait, not finished, it's got a second part. And aren't those numbers the numbers that are included in that Exhibit D to the stipulation, numbers like the weighted average cost of capital and the cap structure and the return on equity? I mean, isn't that pretty basic?
Well, it is basic, but then it's a little more complex in this settlement. The overall rate of return within the settlement is used for two specific purposes. However, other parties that did not agree that the overall rate of return in the settlement was reasonable still found that the bottom line revenue requirement is reasonable because of the calculus that was used to develop this revenue requirement. And I believe Mr. Nelson and Mr. Garrett went over that calculus last evening, where you can adjust the overall rate of return and adjust the black box factor and still arrive at the same revenue increase. And that was part of the negotiations across the parties about how we vary the rate of return and vary the black box adjustment to the revenue requirement in order to get to a revenue requirement, which ultimately all the parties in the case found to be just and reasonable and supportive of all customers' best interest and supporting the public interest. Also important in the negotiation was how that revenue increase was spread across the rate classes. It was done reasonably aligned with the variations in cost of service as recommended in this case by the various cost of service witnesses, and ultimately was used to develop rates. And part of that analysis was an assessment of those rates and whether or not they gave reasonable cost-based signals to customers to allow customers to make economic consumption decisions of electric service. Ultimately, we think the interaction between all the parties and the compromises across all the parties resulted in a rate structure that provided adequate compensation to the company, adequate rates that reasonably align with most parties' assessment of the cost of service or a gradual movement towards cost of service, and produce price signals that gives all customers economic incentives to make efficient consumption decisions of electric services.
So then you don't think that the ratepayers and the commission is entitled to have specific numbers that define the settlement?
Well, there is a very clearly defined number, which is the pivoting point of this settlement, and that is the revenue increase to the utility, the spread of that revenue increase across rate classes, and ultimately the development of rates that would be charged to customers. I think with those critical factors in the settlement, all the parties were able to make the finding that this settlement is in the public interest and benefits all ratepayers.
But as to traditional rate making terms defining the concepts of rate making principles, like the capital structure and the return on equity and the weighted average cost of capital, you do not believe that the commission and its ratepayers are entitled to know any specific numbers that relate to the settlement?
Well, the settlement does provide the overall rate of return of 7.07 and 9.35% for two specific purposes that will have an impact on customers going forward and the utility.
Which are?
The determination of the revenue requirement for the Sagamore and Hale wind farms for assessments of the benefits to customers at a later time.
Yes, sir.
And the reconciliation statements requiring an overall rate of return.
All right, sir. Anything further on that?
Well, there were parties that might agree. I think the overall rate of return in this settlement, as stated, is reasonable, particularly with the black box adjustments that would resolve other issues I had with the overall cost of service measurement by the utility. So my assessment is, with this reasonable rate of return and with the black box adjustment, the revenue increase in the settlement is reasonable. Without the black box adjustment, I may not have reached that conclusion. Other parties may have taken issue with the overall rate of return and may not have had the same issues I had with other portions of the utilities cost of service, but nevertheless still found that the revenue increase included in this settlement was consistent with protecting the public interest.
So in this illustrative exhibit, setting forth the 7.07, you believe that is a reasonable rate of return?
Personally, I do, yes. There are other parties that would not agree with that, which is why the settlement was structured in a way where nobody had to commit to that rate of return as reasonable if they thought it was not, but they could still find that the settlement revenue requirement was reasonable.
But if we engage in let's pretend, which the parties seem to be doing, and it seems as what I heard yesterday, that if you wanted to increase or decrease the cost of common equity, I think the testimony was if you want to move it up or down 10 basis points, that it equated to $1.2 million. Is that what you heard?
That is what I heard, yes.
So then if we wanted to make it 9.25, and then that's going to affect your unspecified adjustment, correct?
Correct.
Okay, is that also going to then affect your overall rate of return?
It would, yes.
Okay, so then that might change it to where you didn't think it was reasonable?
Well, the revenue requirement increase I would find to be reasonable. That change specifically would be within the range of reasonable returns on equity. So I would not find that to be unreasonable.
Okay.
But importantly, I do not find that the 7.07 is unreasonable.
Right.
I would note that if there is a change in the rate of return, there would also have to be a change in the estimate of the revenue requirement for Sagamore and Hale within the stipulation, because that's an important piece for assessing the economic benefits to customers of those facilities. They'll be conducted at a later date. But that's precisely the kind of conversation between all the parties that took place, where we couldn't agree on the capital structure and overall rate of return, but we could agree on a bottom line revenue requirement increase.
And how it was going to be distributed among the customer classes.
Wait, yeah, that's correct. Step one was the revenue requirement. Step two was the spread. Step three was the change in rates to accommodate the allocated class revenue increase. All three of those steps were important elements of the stipulation and took quite a bit of work to work through. There was a lot of concession by all parties in producing the end result.
Your Honor, I'm sorry. We'll do voice for SPS. I'm sorry, Your Honor, but well, I would say Mr. Gorman can certainly testify as to his and his client's view. I think we are treading dangerously close to the line on parties' communications during the settlement process. So I would just ask to remind that those communications are not admissible under New Mexico law.
Yes, sir. I understand that. And Mr. Gorman, you understand we don't want to disclose anything specific about the settlement that might be confidential. Correct, sir? Okay.
Thank you.
And I guess my point is a couple, or what I'm trying to understand. I don't have a point, but I guess the point of my question is, based on what I've heard, the parties could change those numbers in Exhibit D as long as the revenue requirement agreement stayed the same and feel comfortable with it.
Well, it's a three-step process. The revenue requirement was agreed on. However you arrive at that revenue increase, all the parties agreed that the $62 million increase was reasonable. The second step on the spread across rate classes was found to be reasonable. And ultimately, the third step in design of rates to produce the allocated class revenue increase was found to be reasonable.
I'm sorry, the design of rates to produce
Each rate class has allocated revenue increase was found to be reasonable.
Thank you, sir.
Okay, so the revenue deficiency, the amount that was going to be allocated to each rate class,
Yes.
and then the specific rate.
Rate adjustments, yes.
Okay. Yeah, and I guess I'm just trying to figure out. So, for example, then say you or somebody, say you're SPS and you wanted a 9.45. You wanted to view this as a 9.45 cost of equity. You could make adjustments to this chart and still end up in the same place and be happy with the overall settlement, right?
And I imagine, yes, you could do that as long as I can imagine the parties would still agree to the bottom line number without the obligation to accept somebody else's interpretation of how the revenue increase was derived.
Okay. And based on your testimony of the three different parts to the settlement, regarding the revenue deficiency final number, if the commission were to accept the revenue deficiency $62 million plus dollars, but change either the amount allocated to a certain class, well, then I guess it would have to change both. If the commission wanted to change some of the rates that had been agreed upon, they would also have to change the amount of the deficiency that was allocated toward that customer class, correct?
Well, I think I would have to talk to council about what would happen in the event the commission wanted to make changes to the settlement and whether or not that would change, whether or not we would be willing to accept the settlement.
And I'm not asking if you'd be willing to accept it. I'm just saying that that it's not just about the commission accepting the revenue deficiency number, but if there might be ramifications to the settlement if the commission adjusted the allocation to the customer class or the actual rate. Mightn't there?
There could be. Again, there were a lot of concessions made across all parties to produce this settlement.
And I think and so I guess suffice it to say, looking at Ms. Alderson's direct testimony, which is now your direct testimony, and this is rebuttal testimony, actually, it says direct on the top, but there was an issue regarding the proposed rate structure proposed by staff, correct?
There was, yes.
And that's at page 6. But according to your stipulation testimony, there's no longer an issue.
Well, there was a compromise for this case. The issues on proper cost allocation will still be advocated by all parties in the next rate case. Our position is that, renewable resources have capacity value and have energy value, and the benefits they provide to the system and to all rate classes should be recognized in allocating those costs across the rate classes. That is our position that we will continue to advocate. But the settlement resolved that issue for this case, and we will raise it again in the next.
And would be willing to participate in any type of commission meeting or inquiry into potential changes to those allocations?
Some sort of workshop. I need to confirm this with clients, with my lawyers, but it's my preliminary understanding that they were supportive of that proposition as a way for administrative efficiency. But budgetary concerns are always a concern.
Okay. Mr. Gorman, anything else you'd like to tell me about the settlement that might clarify your position?
Well, just one comment. I've heard a little concern about these, the impact on the non-fuel rates, which is largely what we negotiated in this case, in comparison to the fuel savings, which really were factors outside of the rate case itself, because they flow through the fuel adjustment clause. we have PPCA. I would note that some of the fuel savings for these wind facilities are largely impacted by production tax credits, producing very positive fuel savings in the early years of these wind facilities. Those production tax credits are only last about 10 years, in my understanding. These facilities will last about 30 years. The high load factor classes will be more detrimentally impacted by the loss of PTC charges or credits once they go away. So at the outset of these facilities, the PTC are providing benefits to all rate classes, particularly the high load factor rate classes because they consume more kilowatt hours. But when those PTCs go away, the high load factor customers will be more detrimentally impacted than will be the lower load factor.
I'm sorry, sir. The high load factor,
Rate classes will be more detrimentally impacted by the loss of PTC credits to fuel charges once those PTC credits go away. So those were also considerations in both the support for the Sagamore and the Hale facilities at the CCN proceeding. It is also something we are cognizant of in allocating and compromising on the spread of the increase in design of rates in this proceeding.
And I'm glad you brought that up because, I was going back and looking at the 17 on 0044 case. And it seemed like to me that back at that time, it seemed like we were looking at around a 25-year time frame for that facility, for those facilities. And I thought I had remembered that the PTCs and the rush to get them, that the PTCs were going to last a less period of time. So currently 10 years for the production tax credits.
That's my understanding. Yeah, I didn't specifically confirm that for this case, but that is my recollection of time period in the CCN proceeding for these units and other wind units that I have been involved in.
Okay.
Certification.
You think there's any chance it could be extended?
It's an IRS call. It's outside the utilities control and the state's control. It's a federal IRS call, and I have not seen anything that would suggest that ITCs, PTC credits would extend beyond the initial term.
Well, haven't some of the personal incentives extended, like for solar and other renewables?
I would have
If
to
you
check.
know.
I'm not aware of them extending the time period on those.
Okay, and I could be thinking about state credits, but it seems like that with most things, the end usually isn't the end, but all right, sir, I believe that's questions that I had for you. Ms. Drake, anything further or any follow-up for Mr. Gorman?
I just had a couple of questions, if I may, Your Honor.
Please.
And I apologize in advance if my internet connection is slow. I'll try to go slowly. Mr. Gorman, good morning.
Good morning.
I just wanted to go over with you a couple of comments that you made in your discussion with the hearing examiner. You were talking with the hearing examiner regarding the various elements that go into the rate making and specifically were looked at in this case. Am I right about that? Things like specific elements such as return on equity and so forth.
I did, yes.
Okay, and you mentioned the Hope and Bluefield standards. My understanding is that you are not a lawyer, are you?
I am not, but the Hope and Bluefield standards set up the economic criteria under which most rate of return witnesses design a rate of return study to offer recommendations to the commission on a rate of return that is fair and reasonable to both customers and the utility.
And in fact, in your experience and your role as an analyst and a consultant and advisor, you've applied those standards over many years, have you not?
I have, yes.
Okay. Is it your understanding and based on your experience, is it under the Hope and Bluefield standards, is it the specific elements that are the key, or is it the end result that is the key?
It's the end result that is the key. And the end result is just and reasonable rates. And in the event the utility is operated in an economic and efficient manner, then they should be provided fair compensation, and the rate of return should maintain their financial integrity and access to capital.
And again, in your experience, is it unusual to have a settlement that's been approved by a commission, where a commission decides the end result is acceptable and reasonable, but does not specify these particular elements that went into the end result? Is that a fair statement?
On an unimposed stipulation, it is my experience that those are generally approved by regulatory commission, with the backdrop that when buyer and sellers come together and negotiate price terms and conditions, that reasonably aligns with
I'm sorry, when buyers and sellers,
come together and negotiate price terms and conditions, that results in tariff rates that serve the public interest.
So in your experience, would this be kind of known colloquially as a black box type of settlement where the specific elements are not specified?
This one would probably be a gray box because there are certain elements that you can kind of move around, and everybody has a pretty good idea of approximately where the overall rate of return would fall, but not exactly. But generally, the parties were able to do an assessment to determine that the revenue increase embodied in this settlement was what they found to be fair and reasonable based on the information that was included in the record and the assessment each of the parties made of that information.
Okay. Do you recall you and the hearing examiner had a discussion where she posited or suggested that, the parties may have played a let's pretend with the revenue requirement and the elements that went into determining that? Do you recall that?
I do recall that, that the parties did work together as best they can to come up with this settlement. And I think the end result of the settlement is what all the parties found to be a just and reasonable result from this case.
And specifically with respect to these elements that might move around a bit, as the hearing examiner noted, do you recall, did the stipulation actually specify a return on equity for a specific purpose in the stipulation?
It did, and that is laid out at page 3 of the stipulation under agreement as to the base rate increase under what is noted as paragraph 1. So there are two very specific purposes for the overall return on equity and the overall rate of return in paragraph 2, that same page of the stipulation. But aside from those two specific purposes, parties did not agree on what the overall rate of return is for this utility.
Okay. Okay, and moving on, do you recall the discussion you had with the hearing examiner regarding the non-fuel costs versus fuel costs?
Yes,
Okay, and I think you mentioned, or you stated that those fuel costs are, I think you said that they were outside this case and that they flow through the fuel clause. Is that correct?
well, they're not base rate elements. All the fuel costs were removed from base rates and were recovered through the FPPCAC. There was no disagreement between any parties about how fuel cost would be spread across rate classes and reflected in fuel charges. So it was a non-issue in determining the base rate revenue requirement. And it was a non-issue in determining the spread of the increase across rate classes, although there was consideration of the fuel savings produced by the Hale and Sagamore wind facilities, and the actual resource value of those facilities, in terms of them providing both capacity benefits to the system as well as energy benefits to the system. But those were positions taken by parties that negotiated a settlement for those costs and arriving at the settled revenue spread in this case.
But I think you have been able to listen to some of the testimony in this case, correct?
Yes.
Okay, and so I'll just by laying foundation, I'll note that this has been an issue of concern, subject to some questions here in this hearing. So I think what I heard you say just now is that the fuel costs or the fuel savings that are noted, and I see that the the hearing examiner has put up Exhibit A. And Madam Hearing Examiner, is this Exhibit A to the stipulation?
It is.
Thank you, ma'am. That's great. So there have been some questions regarding the overall rate impact, which I understand to include both the rate base increase and fuel cost effects. Is that your understanding as well, Mr. Gorman?
It is. The last column percent increase on total revenue reflects both base rate revenues and FPPCAC revenues, as well as EER charges.
Okay.
EER?
Yeah, 2 E's and an R.
EER, what else did you say? As well as an EER?
A charge.
Thank you.
Okay.
And what is in the EER?
Environmental charges.
Go ahead, Mr. A.
Thank you, ma'am. So Mr. Gorman, of the columns that are shown on this chart, stipulation Exhibit A, what was the focus of this case in terms of what increases were addressed in this particular case?
We largely focused on resolving the differences between the parties in the allocation of the base rate increase, the $62.4 million increase.
So let me know if I'm right about this. That would be the fourth column from the left of numbers in this Exhibit A, page 1 of 7 to the stipulation. Am I right about that?
Yeah, the third and fourth. The third column is the dollar numbers. The fourth is percent change.
Okay, thank you. And then the columns to the right of that address the FPPCAC increase, which I take to be the fuel clause increase, and other matters with respect to this EER increase, and then some of the total figures. Is that correct?
That is correct.
Okay. Were the fuel savings at issue in this case with respect to the revenue requirement?
Well, there was one element of the revenue requirement that had to comply, that the Sagamore base rate increase was being offset by fuel savings. So that's why it was made a point of reference in this case. It satisfied that criteria. But other than that, the case focused on base rate revenue increases.
Is that because this is a base rate case?
Yes,
It's not a fuel clause adjustment case, is it?
that's correct.
So those fuel savings in this chart that we see here, would they have flowed through to customers regardless of this case?
Yes, it's my understanding they would.
Okay.
Mr. Gorman, there's also another component in the settlement that has to do with the transition from the base rates into the FAPCAC, correct?
That is correct, yes.
And so that's going to be an additional savings that's going to flow through the FPPCAC that is not included in the column showing the decreases on Exhibit A, is it?
It's my understanding the FPPCAC increase relates to the expected fuel savings from the Sagamore unit. And that number aligns with the estimated revenue requirement of the Sagamore unit, which is identified page 3 of the settlement, around $38 million. So that shows that the fuel savings at the Sagamore unit exceeds the base rate increase for that same unit.
But so the answer is it does, that's all it includes.
That's my understanding, yes.
Okay, thank you. Go ahead, Ms. Drake.
I just wanted to finish up here by confirming with Mr. Gorman that in terms of the rate spread or the allocation amongst the classes, what was allocated in this settlement, in this case, is the pursuant to, I'm looking at the column labeled percent base rate increase. It's the fourth column over from the left. Do you see that?
I do.
Okay. So it's that percent increase or the actual base rate increase, which is just to the column to the left of that. It's the third from the left. That is the amount that the parties agreed to allocate pursuant to the settlement in this case, is it not?
It is.
Okay, so it didn't take into account fuel cost savings that are in the columns to the right on the table?
Well, I don't believe in testimony anybody took issue with how to spread fuel cost savings.
I don't believe anybody took issue.
With how to spread fuel cost savings in this case. So it's my understanding that the FPPCAC increase spread was non-contested.
And that what was focused on in the settlement here is the base rate increase spread. Is that
Yes.
correct?
It is.
Okay. Thank you, ma'am.
So I thought I heard you testify that the savings were part of the,
Well,
that's what people were thinking about too.
there was a test of whether or not the revenue requirement for Sagamore was offset by fuel cost, consistent with the commitments the utility made in the certification case. So that was a piece of evidence that the utility offered that proved that there was benefits to the Sagamore that offset the increase in rates.
Okay. Ms. Drake,
Those were all
anything further?
Nothing further at this time, ma'am. Thank you.
Okay. And I guess just 2 points Mr. Gorman, and looking back at exhibit exhibit D, when I was asking you questions and about that exhibit, let's look at it that way. It might be a little more challenging.
I think it's upside down now. There you go.
Is that, like I say, perhaps a bit inartfully calling it let's pretend, but my what I was trying to ask and figure out is there's different ways for the parties to plug in different numbers and still come out with a result that they could live with, correct?
Yeah, there is. I think it might be fair to characterize it as the parties may not agree with the specific overall rate of return, but they do agree that the revenue increase is appropriate because the math in this equation allows for changes in the unspecified adjustment to accommodate an assessment of the overall revenue requirement for this utility to align with what they think to be they thought to be just and reasonable.
Okay. And I don't want to give the impression to the parties that I was making light of their negotiations. I'm just, again, trying to figure out from the commission's perspective what information we need and whether or not it's being supplied. So my final question, Mr. Gorman, is, and I think you probably heard this yesterday, is that potentially one of the things that the commission needs to know and why it might be good to have these numbers is that sometimes the return on equity is actually, and the weighted average cost of capital are used to set other rates or charges. Do you agree with that?
I do.
And I'm just wondering that whether or not you have an opinion about how, if the parties are not actually agreeing to these numbers, save the specific ROE numbers that you've already testified to for those two limited purposes, then based on your knowledge, experience, and past practice with the commission, what numbers would the commission use?
Well, I believe I heard Mr. Cole discuss that yesterday. One of the larger numbers would be the AFUDC rate. AFUDC rate is typically based on the utility's cost of short-term debt first. And
Sorry, the AFUDC rate is basically
based on the utility's cost of short-term debt first. To the extent the construction work in progress balance is larger than the short-term debt balance, then that increment is financed with long-term capital. The commission will need to approve the rate of return that would be applied to that increment if one should ever exist. And from that standpoint, I don't know if the parties have come to a conclusion, although I did hear the AG witness say that should not be material. So I would suggest the commission make a finding on the rate of return that would apply to those incremental rate-making factors. And from that standpoint, I can speak for myself that the overall rate of return in this, as stated in the stipulation, is reasonable with the adjustment to other cost of service components, which produces the settlement revenue requirement.
So basically then, from your perspective, you'd recommend that if it were necessary for the commission to set a number to determine the AFUDC rate in the future, or some other, potentially some other carrying charge rate that the commission similarly sets, you would recommend the 7.07?
Yeah, that's not part of the settlement, but I think that would be reasonable, yes.
Okay. Thank you, sir. Ms. Drake, anything further?
No, ma'am, thank you.
Any questions from party?
Your Honor,
Mr. Du Bois, I see, do you have questions for Mr. Gorman?
very briefly, please, Your Honor.
Go ahead. Go ahead.
Good morning, Mr. Gorman.
Good morning.
As you discussed previously, you've testified a number of times over a meaningful period of time in New Mexico. Is that fair to say?
It is.
And New Mexico is not the only state you've worked on these issues in, correct?
That is correct.
And you were, I believe, a witness in SPS's 2015 to 2016 rate case. Is that correct?
Yes.
I don't know if you're better at case numbers than I am, but if I represented, it was 15-00296. Would that sound right to you?
I'd have to check. I know I've been in SPS's at least their last 3 or 4 rate cases.
Thank you. Do you recall we'll call it 2015 rate case as having resulted in a black box settlement?
It was settled. I would have to go back and look at that settlement to see if it was a black box settlement, but I just can't confirm that as I sit here.
Okay. Well, thank you. If given that answer, I'll just stop there. Thank you, Mr. Gorman. Thank you, Your Honor.
Thank you, Mr. Du Bois. Mr. Gorman, thank you very much for your time, sir. You are excused.
Thank you. And again, I apologize for the mix-up yesterday.
Not a problem, sir. Have a nice weekend.
Thank you.
I believe probably we want to go ahead and take our 10-minute recess, and then so until 10:45, and we'll come back, and I have a few questions for SPS witness Mr. Grant. And then after that, I have some questions for Mr. Tupler from staff and Ms. Ramey from staff. So things seem to be going a bit more expeditious than I had anticipated. So with that, let's recess for 10 minutes.
Judge? You're on mute.
Not now.
All right, if we are close and you want to work through lunch, that's fine with me.
All right, sir. I appreciate that. Thank you.
You bet.
Okay, I think we are ready to resume our hearing from our recess. Mr. Du Bois,
Yes, Your Honor.
is Mr. Grant available?
I understood that he is in the waiting room.
He is in the waiting room now. Mr. Grant, hello. Unmute yourself. Awesome.
Good morning.
Good morning, sir. Thanks for coming back.
No problem.
It's so much fun. We thought maybe you just would want to return. You remember you're still under oath, and correct, sir?
Yes, I am.
Okay. And so the question came up. I'm sure probably Mr. Du Bois told you if you weren't listening. The question came up about, since the parties are saying that, and let me share the screen again. I unshared it. There we go. Since the parties have pointed out that the stipulation only, did you just listen to Mr. Gorman's testimony?
Yes, ma'am, I did.
Okay. Are you in agreement with Mr. Gorman that the stipulation only, that the agreement of the parties is that the 9.35 equity number is only being used for two purposes?
Yes, ma'am, I do, and I can explain further if you want me to.
Well, here's my question. Are there instances where the commission needs to know a specified return on equity in order to utilize that number to figure out some other charge?
No, there's not that I'm aware of. For example, this is not the first settlement that we've had. Well, we are specifying an ROE here because it was in the procedural order. But we've had previous settlements where we did not specify an ROE. And in this particular case, we were required to have a reconciliation sheet. Plus, we had to determine what a cost of service was for Helen Sagamore for the purposes of the guarantees that we made in that CCN case. We could have actually agreed to a cost of service without actually applying an ROE to that if necessary, but because we had to come up with one for the procedural order anyway, we utilized the same ROE number.
Right, but what then if the parties are not agreeing to any particular, well, let me ask you this. Are the parties agreeing to any particular cap structure for the settlement?
Stated in the settlement, the cap structure was specified. Now, whether everybody agreed with that or not, it was part of the settlement language, but I don't know what each party has reflected in their unspecified adjustments. But for the purpose of the stipulation, yes, the parties did agree that we would utilize the 54.72 or what is considered our actual cap structure for that.
Sorry, we agreed, the parties agreed that we would
specify that amount in the stipulation, which happens to be equal to our actual cap structure.
And do you believe that the parties agreed to an overall rate of return?
What I believe is everything was considered, the party's position, our position in the settlement to come up with the revenue requirement, which did consider all the parties' positions on the rate of return or return on equity plus the cap structure. So all those things were considered. And, the company had its position, the parties had their positions. And as the testimony earlier in this case, even from, other parties, we came very close to what a lot of people's positions were in this case. And there was a little bit of compromise on all parties' position. But my point is yes, ROE, cap structure, everything was considered by all the parties in the revenue requirement that we agreed to.
Well, I understand that, but I want to know numbers, Mr. Grant. So isn't it true that you actually use the weighted average cost of capital to determine certain carrying charges?
My understanding, the FERC rule, and I heard AFDUC mentioned earlier in the case, for example, FERC rules require us to use our largest jurisdiction. So we are actually prohibited from using the New Mexico equity component in our AFDUC. FERC requires us to use our largest jurisdiction, which is what the FERC rules of accounting are. So it would not be used for that purpose. And of course, we do manage our cap structure to what we agreed to. But for those purposes, I could not think of anything it would be used for, because once we have the settlement, we have our revenue requirement, and that's what we would bill off of.
So you're saying that the return on equity, the cap structure, and the weighted average cost of capital or rate of return number, that you don't need those specific numbers to be authorized by the commission in order to set any rate or carrying charge that SPS uses?
I think what my testimony will reflect, except for the rule in the procurement, in the procedural rules, I mean, what you laid out in the procedural requirements, and trying to come up with a revenue requirement for our after the fact analysis of Helen Sagamore, we would not probably have even put an ROE or an equity structure into the settlement. It would have been a black box.
So the answer to my question is what?
The answer to your question is once we settle this case, those numbers will not be used for anything else.
but my question was specifically, do you or do you not use those numbers as reflected in page 6 of Exhibit A to the, or Exhibit D to the stipulation on the screen, that you don't use those actual numbers when you calculate any rate or carrying charge for a New Mexico customer?
It is my testimony that we were required, the Schedule D that's in the, that you're showing on the screen was a requirement of the procedural order. And that's what the purpose it's serving is to, and we're using the 9.35 for that purposes. You'll also notice on this sheet that there's still some unspecified adjustments and everything else. So as you went over with Mr. Gorman, this sheet still reflects the fact that there was not an agreement from the parties for 935. There was only agreement from the parties to utilize that for this specific requirement and example in the procedural order. And no, we do not need those numbers for the purposes of, we've agreed to the revenue requirement, we've agreed to the class cost of service, and we would utilize those for the billing.
Okay, but you're still not answering my specific question. My specific question is, do you utilize any of those numbers in determining any rate or carrying charge or any other type of expense that is allocated or billed to New Mexico customers?
It is my understanding that we do not.
Do you know how that your current AFUDC rate is what it is and what it's based on?
I know what it's based on. I don't know the specific number, but our largest jurisdiction would be the state of Texas, and it would be the actual capital structure that we have in that state that's been agreed to. As I explained earlier, the FERC accounting rules require us to use our largest jurisdiction, which for SPS, that would be our Texas jurisdiction.
Okay. Well, I have to say that's a different answer than I anticipated, Mr. Grant. I did think that there were some carrying charges that SPS has requested in past cases that were based upon the weighted average cost of capital. But you're indicating, to the best of your knowledge, that's not true, correct?
Yes, let me clarify that we do have a couple of riders that when we do request a structure to be applied to that rider, we have traditionally requested the ROE that is prevailing at the time. For example, we do have an electric vehicle case that has been filed, and we do have a AMI case that has been filed where we requested a 9.45. But it is my understanding that the commission, those are not sitting rates. Those are just setting the ROE for those riders until the next base rate case where those would be determined. However, if I also understand correctly, New Mexico can determine which ROE that they want to give us or to apply to those riders, and they're not bound to use the last litigated case.
And are you saying a 9.45 comes from the last litigated case?
That was the last, last agreed upon. It was the last stipulation, and I apologize, I misspoke. It was not a litigated case. We did have a settlement, but we did agree to specify in that case where the parties did agree to the 9.45. So it was not like this case where there was still a difference in some of the parties where we agreed to the revenue requirement. So it is our last agreed to ROE, which is the 9.45.
And that's from case number 19-00170.
Yes, that is from the 19 base rate case.
Okay. So you're saying an ROE number is important, at least in as it relates to riders, not necessarily carrying charges, correct?
That would be correct. In other words, and as I also testified, that the commission is not, it's been our practice to utilize, the last agreed to ROE, but it's not a requirement from the commission. Because like most riders, as soon as you file the next base rate case, you bring that revenue requirement from the rider into the base rate case.
Has SPS ever insisted that it rely on the last litigated rate case?
To my
In
recollection,
setting,
I'm sorry, Commissioner. Aaron Examiner. Go ahead.
in setting a rate charge rider component for anything that SPS is trying to recover money for.
As I testified to, not that I'm aware of, except for the, like I said, the riders that we have. And what we try to utilize there, just to be consistent, is the last agreed to ROE, but like I said, the commission is not bound to that.
Okay.
I will go on to say that
Okay,
we had plenty of settlements before 15 where we never specified an equity ratio nor a return on equity. My understanding that some commissioners at that time decided it would be, good to go ahead and specify one in settlements. But before that, we've had plenty of cases where we never specified an ROE, as Mr. Gorman testified that was his experience as well.
and so then, Mr. Grant, basically then it's the company's position that we don't need, that the commission doesn't actually need to set, again, except for the limited purposes.
sorry, Judge. I'm sorry,
already
Judge.
test-
I'm sorry, Judge, you broke up. Commission doesn't actually need to set.
a return on equity or arrive at a rate of return in order to approve the stipulation.
Yes, it is the company's position, and as testified by other parties as well, that the 9.35 is only utilized for two specific purposes: the reconciliation sheet, as you have up on the screen, and for the purposes of determining what our hurdle is for measuring the savings of the Hill and Sagamore Wind Farm.
And you're saying hurdle?
When you measure savings, you have to have your cost identified. So I consider that to be the hurdle we have to overcome before I can say we have savings. So that's why I call it a hurdle. In other words, did I have savings? Well, the fuel savings had to be over what my cost of service was for those facilities.
Okay. And Mr. Grant, does the company have a position on as has been testified to by the last non-SPS witnesses that, for example, if you wanted to view Exhibit D differently, you could change some of the numbers, but still arrive at the revenue deficiency? Do you agree with that?
I do agree that on this sheet, if you change the numbers, you could still arrive at the $62.4 million numbers. Yeah, that is true. I mean, like I said, there is still an unspecified amount within those tables.
Do you believe that the commission could adopt the revenue deficiency number and reallocate some of the revenue deficiencies differently?
And I think as testified earlier, I do believe the commission has the authority to do that. However, as also testified earlier, parties would have to determine whether they would still support the stipulation or not.
I mean, I can understand from the other parties' positions that depending on who they represent, which type of customer class, that it might make a difference. But does it make a difference to SPS as long as it gets its money?
Well, you know, that's my answer is probably going to surprise you, but yes, it does matter to SPS. For example, I think, as you've heard in testimony, there was a lot of thought process, a lot of parties back and forth, and parties representing their interests. But at the end of the day, these are our customers, and we have that relationship with our customers. So yes, we do. It does matter to us. Because we serve these customers and have a long-standing relationship with them. So it matters to me what the cost of service is, but I do believe the settlement is very just and reasonable, and a lot of work and a lot of thought went into what was agreed upon.
Very well, Mr. Grant. Thank you for coming back.
You're welcome.
I did have one more question, actually. Does the type of settlement entered into in this stipulation, with some of the numbers not being specified, have an impact on a future rate case filing, and what type of rate case filing it is? Do you understand my question?
I do understand your question, but I think each and every case stands on its own merits. In other words, you have your and it's been my experience that when it comes to when you get ready to file a rate case, you have a revenue deficiency, and there are different types of drivers to those cases. No two cases are ever the same. And within that case, then you would start talking about, your rate design, your revenue requirement, and negotiate and work through or litigate with the parties on what the final outcome. I will agree that the only thing that it impacts is you have your starting points based on the settlement for what each class customer is paying. So when there is a change in rates, you would have a change in percentages and stuff like that. But I do believe that most cases stand on their own merit, and your cost of service and rate design would be determined in the next case as well, just like it is on this one.
And I guess I was more specifically trying to look at, does this put SPS in a positive, negative, or neutral position for its next rate case, and whether or not that would be a future test year or a historic test year?
Well, Madam Hearing Examiner, I know that we have filed historic test years the last few times, and would probably lean that way in our next case as well. I do know that we have the right to file forward-looking test years, but experience that the historical look is what more people are comfortable with, and looking at our rates. As far as a favorable position, I think Ms. Martin testified that we believe that settlement is fair and we believe it's equitable. I think the parties heard our concerns, and we definitely heard their concerns. You do understand it's well lower than what our ask was in this case. So I also heard Ms. Martin testify, and I agree that this would be looked upon as favorable because the parties came to agree to it. But it is fair and equitable, but it by no means is slanted towards the company's outcome. It's a fair and equitable outcome.
And I wasn't trying to suggest that, Mr. Grant. I just was trying to look forward. And I thought, as part of the 170044 case, the CCN case, I thought that ended up being part of the stipulation in that case, that SPS, because at that time, SPS was filing future test year cases, correct? If you know.
We have filed two future. One was successfully litigated. One was actually thrown out. And it's been our experience that there is a lot of work needs to be done with the rate filing package for a future test year before people are comfortable with that. I'm not disagreeing that companies have the ability to file future test years under New Mexico statute. But it's been our experience that it's not a common practice, and there needs to be some work with agreements and what is presented in those cases before it makes it a viable option.
Okay, and like I say, I just seem to recall that as part of the stipulation in the wind farm CCN cases, that SPS actually agreed in that stipulation to file historic rate cases for the two wind farms. And do you know if that's correct?
We did agree that when the plants went commercial, we would file as soon as practical a historic test year. And we also agreed that we would also file again in 2025 to address the ADIT issue. So yeah, there was a couple of agreements in that case, but I think you specifically asked me what our plans were for the next case. And of course, the company will evaluate which one is actually better for us to proceed with. But at this time, I think we're leaning towards an historic test year.
And my ultimate question was, does the settlement, provide a benefit toward either a historic rate case in the future or a future test year? That
I don't know what you mean by benefit, because I will share with you that we do have even though our load growth has been flat, we still do have load growth in southeastern New Mexico that and we do still have some capital spend that's necessary to provide reliable service in that area.
Some capital spend that is necessary.
To provide reliable and economic service to that area. So we do have some capital spend that has been spent already that is not reflected in this rate case. And of course, for that purposes, I mean, we still go forward, but again, we are pleased with the effort that was put into the settlement. We think it puts us in a good position, but it by no means gets us ahead of the game.
Okay. Well, I still don't think that answers my question, but maybe there's not an answer to my question. I just figure people are, we have our enumerated benefits, and then I'm sure parties have, are always planning for the future. So I'll just take your answer as it stands, Mr. Grant, and ask you, I guess, finally, any idea when that next rate case might be?
We are looking somewhere, I believe, in fall of 23.
Okay. All right, sir. Thank you, Mr. Du Bois. Anything further? Any follow-up?
Yes, please, if I may, Your Honor.
Please.
Thank you. And I will apologize in advance if this gets tedious, but I really wanted to break down into very tiny pieces some of the questions that I thought I was hearing that I wonder if there may have been some, well, I'll just stop there, but I want to break it down really minutely on the topics that were just covered. I'll start maybe, Mr. Grant, with the reconciliation statement that we keep talking about. Is that reconciliation statement used for anything going forward?
No, it is not.
Okay. On the topic of carrying charges, you mentioned, and others have mentioned, AFUDC. To be clear, what does SPS have to use as an AFUDC number?
We have to use the largest jurisdiction that we have, or our actual cost, the way I understand the accounting rules with FERC, our actual structure.
Oh, I should break it down. So strictly on return on equity, what does SPS have to use for AFUDC purposes?
I believe we defer back to the last agreed upon ROE that we have, but I'm not sure exactly what the accounting rules on the ROE component of that.
I'm sorry, the last agreed upon ROE in which jurisdiction?
The largest jurisdiction.
Okay. And for the capital structure component, what is SPS required to use?
Again, it is the largest jurisdiction's capital structure, or our actual cap structure, depending on if we've had a litigated case. But it's, long story short, for both of those purposes, we have to use our largest jurisdiction according to FERC accounting rules.
Okay. And there isn't any other carrying charge either where a New Mexico ROE or rate of return would be used, correct?
Not that I'm aware of.
Okay. Coming back specifically to riders. First, the commission has to approve whatever rate of return is used for the purposes of a rider, correct?
That is correct.
And SPS in its initial filings has frequently used the last specified rate of return, correct?
Yes, that is what we filed.
But SPS could ask for a higher or I suppose a lower rate of return for the rider calculation, correct?
That is correct as well.
And I think you already answered this specifically, so I apologize, but I just want to be sure. If it's actually, sorry, I think it was. Start over. Riders do not constitute the final decision on the return applicable to the assets in the rider anyway, correct?
That is correct. It is.
And that would be.
Yeah, it is taken up in the next rate case.
Okay. And I'm going to give you a couple of hypotheticals on what you were asked about the extent to which the company or a customer might care about where the return on equity is set with respect to the wind project net savings requirement. Do you understand the premise of the questions?
Yeah, in other words, you're
Better to follow.
you're asking me about the customer's concern on a stated ROE for the purposes of calculating the net savings.
And I'm going to use some really extreme examples just to illustrate. On stepping back from this case at all and ignoring the wind provision here, is it fair to say in general, so long as they're not placing an undue burden on customers, companies do like higher returns?
In general, yes.
And is it fair to say that as long as the utilities service and financial stability is not threatened in general, customers like lower revenue requirements, however they get there?
That would be a fair statement, yes.
On this wind condition specifically, however, is it fair to say that it is in the company's interest in meeting the net savings requirement to have a relatively lower return on equity applied to the wind projects?
Absolutely. If we used a lower ROE, then the cost of service for those facilities would be lower. So the savings would have a lower benchmark before there was recognized savings. So that is correct, yes.
And again, just narrowly with respect to the wind projects, customers have an interest in a higher return on equity to drive up the savings requirement, correct?
Yes, they would.
So we're a little bit upside down compared to normal circumstances, perhaps. Is that fair?
That is a fair statement, and for this specified reason, you would want if I'm the customer, I wouldn't want you using something lower than a 935, for example.
But you do recall testimony from various witnesses that the 935 is as applied specifically to what it's applied specifically to is fair, correct?
Yeah, and I think that was part of the discussion. Is the parties recognized that it would be used to set the cost of service for the purposes of doing that analysis. So the customers fully understood in the deliberations what that would be and agreed to it, and so did the company.
And turning now to the future rate case filings question, or series of questions. First off, I may have misheard you, but do you recall what SPS has communicated to parties is the expected timing of its next rate case?
I do know that we, and I'm sorry if I'm drawing a blank. I think we would be filing, and I think I said 23 when I probably should have said fall of 22 for rate impact of 23. What we're, there are some drivers in that would require us to file about that time frame. And to be honest with you, I mean, really what I'm talking about is 2-year gap between cases.
Let's separate return on equity and rate of return on the one hand versus revenue requirement on the other, and keep those two separate for a moment. In the circumstances of this stipulation as structured, does the ROE, for the limited purpose of the reconciliation statement that we've already established, has no applicability going forward, or for the wind projects, influence the timing of that filing at all?
It does not.
On the other hand, we'll say a lower revenue requirement influence the timing of that filing, if you know?
I'm not sure. We'd have to look the numbers, but I'm not sure on the lower one. Of course, if the company is not earning what it needs to earn, we would have to come in sooner rather than later, instead of waiting for the normal drivers to drive that decision. But the company needs to have, it depends on what the numbers are and everything else, but I do agree that if it's lower, it could drive us coming in sooner.
I'm going to try rephrasing a question that I think there's been some lack. Oh, start over. So we've gone through the wind projects as needing a revenue requirement particular to them, which requires having something to point to get there, as one thing that this does do going forward, right?
Yes, and I think I misanswered your previous question. You asked me if a lower ROE would impact. I expanded that scenario to impact the lowering of the revenue requirement. And a specified lower ROE or higher lower ROE would not impact us at all. But a lowering of the revenue requirement would impact our decision on the next case.
So It impacts wind savings hurdle rate as you've described it.
I'm sorry. It impacts wind, W-I-N-D.
Correct.
Did you start again?
The stipulation ROE impacts the wind savings hurdle rate as you've described it.
Mhm.
Is that fair?
That is a true statement.
It is needed for this reconciliation statement that doesn't do anything else. Is that fair?
That is a true statement.
It can't be used, even if SPS wanted to, or this commission ordered it to, be used for AFUDC or any other carrying charge, correct?
Yeah, as I said, I think we're actually prohibited from doing it according to the FERC accounting rules.
It doesn't control what happens in riders. Is that fair?
That's a true statement.
Can you think of anything else that it would impact going forward?
I cannot think of anything else that would impact. As I said, each case would be on its own merits. So no, I don't believe it would impact anything that I can think of.
I know you can't address discussions during settlement, and I'm not asking you what any other party's perspective might have been. But if it weren't for the procedural order and the wind final order, can you say, if you know, whether SPS would have wanted or thought it necessary to have return on equity addressed in the stipulation?
From SPS's position only, and I can't speak for the other parties like you said, but we would probably have had a black box without specifying, nor would we seen the need to specify.
I'm sorry, sir, you broke up. Probably have had a black box.
We probably would have recommended a black box settlement, nor would we felt compelled to identify an ROE or a equity to debt ratio.
To be fair, would SPS have been happy to specify a higher ROE that would be used to calculate a higher revenue requirement?
That's pretty speculative, Mr.
All right.
Rice.
All right. Thank you, Your Honor. I'll stop there.
Okay. Anything further
Thank you.
from anyone else? Hearing nothing. Mr. Grant, you're excused
Yes,
for
ma'am.
real this time.
Thank you.
Thank you, sir. Mr. Bagatko,
Yes, Madam Hearing Examiner. Good morning.
good morning. You have a witness.
Yes, I do. I believe he's already in the bullpen, so to speak. Mr. Mark Tupler.
He is. Good morning, Mr. Tupler.
Good morning, Madam Hearing Examiner.
Mr. Lee, would you swear in Mr. Tupler, please?
Mr. Tupler, would you raise your right hand, please? You solemnly swear the testimony you're about to give in the matter now pending should be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you, sir.
Thank you, Mr. Lee. Mr. Tupler, is it fair to say that your testimony on behalf of staff changed?
To the
From your
point of the
original direct position?
yes, ma'am. Slightly.
And some of the items that you identified in your testimony for example, page 2 of your testimony in support of the stipulation. Line 6, you pose the question, does section 1 of the stipulation identify specific cost of service components associated with base rate revenue?
I'm sorry, Judge, specific costs of
Service components associated with base rate revenue. And your answer beginning on line 8 says yes. Section 1 identifies among other stipulated terms the following stated cost of service components analyzed in my direct testimony. And then you list 3, you list a return on equity of 9.35%, a capital structure consisting of 54.72% common equity and 45.28% long-term debt. And then finally, a tax unadjusted weighted average cost of capital, or WACC, WACC, of 7.07. Is that correct, sir?
Yes, ma'am.
And is it your understanding, Mr. Tupler, that while section 1 might identify those terms, as we've been hearing from the other witnesses, is it staff's understanding that there is not an agreement that those are terms that the commission can rely upon as being agreed upon?
One of the important elements I believe I had in mind at the time, and I still have now, is that this stipulation was an agreement amongst the parties and a meeting of the minds. That's an important phrase, in my opinion, because these numbers are kind of derived, is a way I would say it, to make the agreement work. I think it's important that that meeting of the minds accepts the stated terms in the stipulation. I believe it's within the power of the commission to hold the parties to that.
Well,
Does that answer the question sufficiently?
not necessarily, Mr. Tupler.
I can try again.
Well, basically what I have heard, and you probably have heard if you have been tuning in, is I think some of the other parties have gone out of their way, for example, to say the terms, for example, in the numbers that are derived in stipulation exhibit D that we've been looking at, which I will pull up again. That, for example, when you're looking at page 6 of 7 of exhibit D to the stipulation, that this document is putting in numbers that show us how we can arrive at certain numbers and ultimately want to arrive. I guess the document wants to show how the parties came up with a revenue deficiency, or at least one version of here's how you could come up with the revenue deficiency. But what I've been being told, Mr. Tupler, is that except for a couple of limited purposes, nobody is agreeing to the number except the bottom line revenue deficiency, except that the illustrative 9.35 is going to be used to determine the cost savings in the wind farm cases. And oh, by the way, we're also putting it in there because you made us. Okay.
Right.
And do you agree with that or not?
Considering it's a very stated term in the stipulation and that staff supports the stipulation, I would agree with that.
Okay. So then are you in agreement that the rest of these numbers as illustrated on page 6 of 7, the numbers, for example, for the capital structure, the debt and equity numbers, do you also agree that those are just for illustrative purposes?
Again, I'm going to fall back to the fact that the parties had a meeting of the mind on those numbers, so they work for the purposes of this stipulation. And I don't know how to go any further with that answer.
Well, I guess what I'm asking you, Mr. Tupler, is that a number that you believe is just being utilized to support the ultimate revenue requirement deficiency? Or do you believe, for example, if there was a reason that the commission needed to actually say, okay, we need to compare what's going on now to what their cap structure is? And we know their cap structure number is because it was stated in case number 20-00238.
Yeah, so the question is about the capital structure, or all of the numbers are we talking?
I'm talking about right now the capital structure.
Okay.
Because you've already told me that the 9.35 is just for limited purpose. So
Right.
what about this cap structure number? Is it real or pretend, Mr. Tupler?
In this stipulation, I'm going to call it real, because undoing any element of the stipulation, I believe, affects every other number in the calculation, or the reconciliation, maybe more properly. And it was agreed upon by all the parties. A meeting of the minds, I've said before, I believe is an important characterization in a stipulation, which results in a very solid number.
Okay. What about the weighted average cost of capital number that is in this illustrative exhibit? Do you believe that's a number that the commission can say that SPS's weighted average cost of capital that results from the evidence in 20-238 is now 7.07?
Unless there's some other precedent to determine that, and I believe we've heard maybe a couple different examples of how it could be used. I support that weighted average cost of capital number because it's strictly a function of the input numbers.
Okay. So then you're saying that is a specific number the commission can rely on.
Yes,
Okay. And you do realize that your last two answers are different than the prior witnesses.
I think I have maybe a different perspective on a few different things, no question, but this is my professional judgment.
Okay. How many return on equity cases have you testified in, Mr. Tupler?
I believe this to be the third for the New Mexico PRC.
Okay. And have you done any outside of the PRC?
Well, in my professional career, I was an investment analyst and a financial advisor, so it was just part of the daily routine. I've done thousands of return on equity analysis studies, if we can call them that.
And Mr. Tupler, your recommendation in your direct testimony, I believe you had a range of from 9 to 9.44 on ROE. Is that correct?
That sounds accurate, yes.
Okay, but you chose a 9.22.
Yes, ma'am.
Okay, and why was that?
Well, based on the other analysis components, if I can call it that, I figured as part of my duty to balance the public interest, I don't want to be too high because that advantages the company. I don't want to be too low because it advantages the consumers. Right in the middle, in my opinion, is the absolute definition of balance of public interest.
And the illustrative 9.35 ROE that was set forth in the stipulation, that's higher than your 9.22, correct?
Yes, ma'am.
But yet you were in agreement with that, correct?
Yes, ma'am.
And why is that?
Well, two reasons. First and foremost, it was 13 basis points away from my recommended number. 13 basis points, in my opinion, is a very reasonable negotiated move from my original recommendation. Plus, it was very well within my range of reasonableness that I established in my original direct testimony. So anywhere along that range could be considered reasonable, almost by definition.
Were you the return on equity witness in El Paso Electric's recent rate case?
Yes, ma'am.
What did you recommend for an ROE in that case?
Ooh, I think, I'm sure you can appreciate that at some point the numbers become jumbled in one's brain.
If you remember.
I believe it was maybe a 9.3, 9.35, somewhere along that line. I wish I could give you an exact answer, but I don't have that case right up, but I could, of course, subject to check.
Okay. Well, suffice it to say that neither the hearing examiner nor the commission accepted staff's recommendation in that case, did they?
Yeah, no, disappointingly, they didn't.
And as a matter of fact, the commission set a 9.0 return on equity in that case. Is that correct?
Yes, ma'am.
And Mr. Tupler, is there a reason that you believe that based upon the reasons for the hearing examiner's decision and the commission's decision of setting an ROE of 9, is there any reason that you have why you thought that the commission would set a 9.35 in this case?
I didn't expect that.
Well, didn't the decision come out before you entered into the stipulation?
I think it came out pretty close to or right within the start of the stipulation negotiations. I do remember that, yes.
Well, I'm just wondering if it gave you any pause to consider your ROE testimony. I know staff didn't file any rebuttal testimony, but if it gave you any pause when you entered into the negotiation or the ultimate stipulation, the whether or not the commission's EPE decision gave you any pause?
Well, it certainly caught my attention. There's no question about it. The biggest concern I had at the time that maybe my numbers were wrong or that I had made an error in the models that I was using. I believe that my model and most importantly, my peer group were extremely solid. They had basis, they had foundation. I used pure data, not adjusted or adjusted is the best word, data. So my analysis was based strictly on analytics of publicly available market data. I went back and reviewed, I was solid. So it didn't change my opinion of my recommended ROE. I used that.
I know, I'm sorry, go ahead, sir.
I was going to say, I used that position to kind of fortify my stance of where the settled or stipulated ROE should be, somewhere around what I recommended originally.
And I note that on page 4 of your stip testimony, at lines 9 through 11, you're referring to some research, regulatory research associates reports that include, that are from the summer of 2020, correct?
Yes, ma'am.
Did you not feel the need to update to include the full year of 2020?
I did, but limited resources prevented that, is I guess the way to put it from my perspective. However, I would tell you that information from 2020 is not considered outdated in any way if we're talking about market related or investment time period data. There's slight changes day to day, week to week, month to month, year to year, decade to decade. The further out you can take your analysis, in my opinion, from my chair, the better the result. Immediate data serves no purpose, in my opinion.
Why?
The markets are too volatile short term. Successful long-term investors don't care what happens today. They may not even care what happens this year. They care about long-term trends only. In my experience.
Sir, if you would look at, I think if you've been listening to the testimony, and there's been quite a bit of testimony with regard to what's on the screen right now, which is Exhibit A, page 1. Basically, that's the settlement rate design. Was that part of what you were looking at when you ultimately agreed to the revenue deficiency number and allocation?
Well, respectfully, Madam Hearing Examiner, that was not my assignment in this case. That might be a better question for witness Ramey. I did not utilize this chart.
Okay. Okay, Mr. Tupler, thank you, sir. Those are the questions I had for you. Any questions from you, Mr. Bagatko?
Madam Hearing Examiner, I am having a little difficulty with my video feed all of a sudden. Just let me unplug it and plug it back in. Sorry about that.
I think we've all been in that position a few times.
Try it again.
There you go. There you are.
Thank you. You know what? No redirect necessary for Mr. Tupler. I would pass the witness. Thank you, Madam Hearing Examiner.
Thank you, Mr. Bagatko. Anyone have any questions for Mr. Tupler?
Yes, Your
Hi
Honor,
there,
please.
Mr. Du Bois. Go ahead, sir.
Thank you, Your Honor. Thank you, Your Honor. Mr. Tupler, you were also a witness. Good morning, by the way. I'm
Yes.
Will Du Bois, counsel for SPS. You were a witness in New Mexico Gas Company's most recent rate case. Is that correct?
That is, yes.
And that case concluded in just in December of 2020. Is that correct?
That sounds about right, yes.
And in that case, if you recall, isn't it correct that the commission ordered a 9.375% ROE?
Oh, Mr. Du Bois, as I mentioned earlier, sometimes the numbers jumble in my head unless I have to think about it, on the spot. I would agree if that is the number presented in the final decision.
Do you have a
Okay.
case number, Mr. Du Bois?
I would represent its case number 19-00317.
Thank you. Go ahead.
Thank you, Your Honor. Mr. Tupler, I'm going to ask a question I don't know the answer to. Were you a witness in Zia's most recent rate case?
No, sir, wasn't my assignment.
Okay. And were you a witness in Public Service Company of New Mexico's most recent rate case?
I believe so. I think my case history attachment in my testimony outlines the cases that I've been involved with. You put me on the spot and I have to verify that.
Fair enough.
Yeah, thank you.
Then if you do recall, do you recall whether the commission authorized a return on equity of over 9.5% in Public Service Company of New Mexico's most recent rate case?
Okay, so I'm going to say that I do not know that, which leads me to believe that that was probably not one of the cases I worked on.
All right. Well, I will stop there then. Thank you, Mr. Tufler.
Yes, sir.
Okay, anything from anyone else? Hearing nothing. You are excused, sir. Thank you.
Good day.
And have a nice weekend.
Thank you.
And I believe Mr. Pagatko, Ms. Ramey is also your witness.
That is correct, Madam Hearing Examiner. Do you see whether Ms. Ramey is in the waiting room for this Zoom proceeding?
I don't see her yet. I just have a few questions for Ms. Ramey. Does anyone object to us continuing on in our luncheon hour? Oh, there she is.
Hello.
Hello, Ms. Ramey. Good morning.
Well, good
Actually,
morning.
my watch says after 12. Good afternoon.
Yes.
Mr. Lee, would you please swear the witness?
Would you raise your right hand, please? Solemnly swear the testimony you're about to give in the matter not pending should be the truth, the whole truth, and nothing but the truth.
Yes.
Thank you, ma'am.
Thank you, Mr. Lee. Ms. Ramey, as I ask most of the witnesses, your original testimony in your stipulation testimony have some differences, don't they?
Yes.
And I guess maybe I should start off where, since before I forget, with a question that Mr. Tupler just deferred to you.
Yes.
If you look up on the screen and you see what we've been looking at a lot, Exhibit A, page 1 of 7, you've seen that before, correct?
Yes, quite a bit.
And as part of your job responsibilities, you looked at the revenue deficiency allocation to each of the customer classes, correct?
I was not the rate design person, but I did look at it from the revenue requirement perspective.
And staff ultimately agreed with the rate design as proposed by the stipulation, correct?
Yes, we did.
And you testified that on page 5 of your stipulation testimony, you stipulate as to the that actually it was pretty close to what staff had recommended in your direct position, correct?
Yes.
So you had to feel pretty good about that, right?
Yes.
And I think you probably, well, I guess it goes without saying, your proposed revenue deficiency allocation was different than what ultimately got approved by the parties, correct?
Yes, it was. A more gradualistic approach, I think, was used in the original rate design. So it was similar to what SPS had originally proposed in that regard for the gradualism.
Because I guess if we were going to characterize staff's proposed rate allocation, the residential ratepayers would have paid less, and the larger customers would have paid more, correct?
Yeah, correct, yes.
And with the allocation now, as you can see, that the average base rate increase is 19.32%, with the total residential being above that at 20.77, correct?
Yes, ma'am.
And you probably have heard some questions during this week about potential negative effects on residential customers, especially those New Mexicans who are on the lower end of the economic scale. Haven't you?
Yes, I have. That's always a concern of the commission.
Well, in putting that in context with the pandemic and the fact that potentially disconnections may start again because of arrearages, was it a concern of staff's?
Oh, absolutely.
Well, if you had a 20.77 increase in one of your bills, wouldn't that give you pause?
Yes, ma'am.
But staff still believes that the revenue deficiency allocations are reasonable.
Well, yes, primarily too, because SPS's overall customer base is a majority of commercial and industrial consumers. And I mean, that doesn't, discount, the impacts to residential, but the residential customer class is approximately 20% of their overall rate classes. And so, we did the best we could to protect them and be fair under the circumstances.
I think if you have been listening, and to the extent did you just hear or have you heard the past few witnesses distinctions with regard to what the parties actually agreed to as far as numbers and how those numbers are being used in this case?
Yes.
Yeah, I want to look at the chart that way. Let's try to get it. There we go. So you've seen this, I'm sure, too. this is page 6 of Exhibit D.
Yes, ma'am.
Okay. And do you have heard about the limited circumstance of the 9.35 in this case?
Yes.
Uh-huh. And then you've also heard the discussions on the debt equity numbers.
Yes.
Okay.
I've
and
heard
then
most of it, yes.
I'm
and
sorry,
then the
ma'am.
result.
I'm sorry, ma'am, you said again?
I have heard most of it, yes.
Thank you.
And then you've also heard testimony on the weighted average cost of capital.
Yes.
Okay. And Mr. Chupler, I believe, just testified that he seemed to be in agreement with the limited usage of the 9.35. But he seemed to, I believe his testimony is different on the cap structure and then the overall weighted cost of capital. Do you have an opinion on whether or not those numbers were agreed to by the parties or are just illustrative?
Staff's view for clarification was that it was not illustrative. It was an agreement of 9.35% with the stated structure of 54.72 and the WAC of 7.07. So staff does not agree and has always taken the view and the position that this was the agreement and it was not for illustrative purposes. And I know in contradiction to all the other witnesses, but staff accepted that as the ROE for this agreement.
And the cap structure and the WAC.
Yes, ma'am.
And one of the reasons I've been asking is, and I believe if you listen this morning, I had some concern of if the commission didn't have an actual ROE or a cap structure that resulted in a weighted average cost of capital, that it might affect some other functions and rate setting and the commission's rate setting ability. Are you aware, Ms. Ramey, of whether or not the commission uses that information to set some other rate, rider, charge?
Well, I don't disagree with what was said previously pertaining to the rate riders. I admit that that is not something that I have focused on. But I know that the FERC rules do apply to that, and it's based on the, in this instance, it would be based on the Texas rate, because that is the largest portion of SPS's territory. And New Mexico is a much smaller portion. So that would not apply, or the commission would not necessarily have the final say in that. But I would want to say that in terms of the other items, and from my perspective as the revenue requirement person, in order to reach the final revenue requirement, you have to have specified ROE, cost of, and the capital structure needs to be specified. And then that in turn once it's run through the models, will impact the weighted average cost of capital calculation. So it is all tied together. And then it is carried through to the rates that the company finally charges each customer.
But as we sit here, you're not aware of anything other than the riders. There's not some other carrying charge or other determination that staff is aware of where those numbers would be utilized.
The carrying charge?
There-
I'm not really sure what you're asking. I'm sorry.
Okay. There's been a question that potentially either for, and I understand the testimony on the AFUDC, and you're in agreement, it sounds like, with Mr. Grant's explanation of FERC rules. So it's not related to that, but
Okay.
it seems to occur, or it occurs to me, that there have been past cases where utilities have wanted to have some type of carrying charge included that utilizes a weighted average cost of capital number. And I'm asking you if you remember specifically an instance of that.
Yes, there are other items that do apply the weighted average cost of capital. Let's see, right offhand, I'm drawing a blank. I apologize. Let's see. I think in some cases, sometimes it's been applied to regulatory assets and liabilities. Let's see, sometimes it's also used for carrying charges for, say, the rate case expenses. So it depends on, I guess, the items in the particular rate case and what is agreed upon or proposed, but they are used in different instances, the weighted average cost of capital.
And if one of those situations came up outside, after this rate case, but before the next rate case, if the commission accepts the other party's positions that these numbers are illustrative, what's the commission going to use?
Well, like I said, I do not believe that, or staff did not take the position that these were illustrative. And the reason being is that if you change the ROE and the cap structure, the weighted average cost of capital changes. And so that flows through and impacts many things. And so if you change one thing, it's going to impact and change the other variables. So if we don't use the 9.35 and the cap structure is shown, the weighted average cost of capital will be a different value. And so that's going to flow through and impact other variables.
Well, are there, you're the accounting and numbers person, Ms. Ramey. If you don't have those numbers going forward, do you believe that you're going to be able to complete any type of financial review or investigation that the commission might want you to do?
No, I need those numbers. That's why I'm saying this is not for illustrative purposes.
Okay. Very well. Those are the questions I have for you, Ms. Ramey. Mr. Bagatko, would you like to ask anything of your witness?
Madam Hearing Examiner, yes, please, just briefly.
Go ahead, sir.
Now the afternoon. Good afternoon, Ms. Ramey. I hope you're well.
Good afternoon.
Directing your attention to the stipulation that was introduced. Do you recall?
Sorry, I can't hear you.
I just wanted to talk briefly about the stipulation in this case. Am I coming through better now?
Yes, thank
Yes.
you.
I would like to look at, if you'll permit me, Madam Hearing Examiner, page 3 of the stipulation, section Roman numeral 1, paragraph 1, please.
Page 3.
Okay.
There you go.
Page 3, Roman numeral 1.
It's on the screen as well, Ms. Ramey.
Oh, okay.
And I was just going to ask you, pursuant to paragraph 1, it is your understanding that the 9.35% ROE, one of its purposes is to be used in conjunction with the reconciliation statements required by Rule 1.2.2.36F. Do you see that there?
Yes, I do.
So going forward, at least the number will be carried forward and reflected for that purpose, and the subsequent analysis at the end of this case, presuming stipulation is granted. Do you follow me?
Right.
Okay. And the same goes for the weighted average cost of capital reflected in that paragraph for that limited purpose. Is that fair to say?
Yes.
And then concerning some of the questions from Madam Hearing Examiner regarding the residential rate class, do you believe that the result of this stipulation in connection with that particular rate class is fair, just, and reasonable under the circumstances of this case?
Yes, I do, because in the end, the overall rate increase is lower than was originally requested by SPS. And it was really pretty much what staff proposed. And with all of the negotiations to reach that point, with all of the various parties involved, I think it was a good outcome.
And on the balance, it's fair to say that the terms of this stipulation are positive.
Oh, yes, yes. I think it benefits all parties. It's fair, just, and reasonable. We worked very hard to get to this point, and we are, moving forward with the transition to renewables that have been mandated by our leaders here in New Mexico.
And going back for a moment to the questions regarding the residential rate class.
I'm sorry, Mr. Bragaco. Your voice is coming through very muffled regarding residential rate.
Regarding the residential rate class, am I coming through better now, Mr. Lee?
No.
Not really.
I apologize. The Xfinity truck was here last night doing some work on the road, so I'm not sure what's going on. You know what? With that, I think I've asked enough on redirect, and I would just conclude it there and pass the witness, Madam Hearing Examiner. And I sure hope you can hear me now, because this is a little disconcerting.
Because this is a little
disconcerting.
Thank you.
Mr. DuBois? Any questions? No?
Yes, Your Honor, briefly, if I may.
Okay.
Good afternoon, Ms. Ramey.
Good afternoon, Mr. DuBois.
Just kind of similarly to with Mr. Grant, I wanted to try breaking down some of these questions into very small pieces on the return on equity and rate of return questions that have been asked. Let me start, if I may, with with the AFUDC number. You already agreed that the rate of return or return on equity from this cannot be used by the company for an AFUDC number because FERC rules prohibit that, correct?
Yes.
Okay. And you can't think of any other carrying charge that this number would be used for, correct?
Unfortunately, I'm drawing a blank, yes. My apologies.
And with respect to riders, I think there has been testimony, though I don't think by SBS, that the commission could choose to set a return for calculating a rider at a 9.35, for example, correct?
I would agree with that, but I would also, state that riders are not what I have testified to, but the commission could probably, I would agree that the commission could do that if it's.
But I'm going to pick up on that if it so chooses. While the commission presumably can, there is absolutely nothing about this that would require the commission to do that, correct?
And absolutely nothing, where are you talking about?
So when, with respect to riders in particular, if the commission were to set a ROE to be used for calculating a rider, which, as you said, would have to be trued up later based on whatever the commission determined. The commission can set it at, for example, a 9.35, but ultimately where it gets set is up to the commission itself, correct?
I would agree with that.
And nothing about this stipulation could possibly bind the commission on what ROE it has to use on a future rider, correct? Unless the commission ordered it itself.
I would say that my testimony did not cover any issues regarding riders. So I would just state that the commission has the authority to set that, but I did not testify about anything pertaining to riders.
Understood. Thank you for that. On regulatory assets in particular, the commission can dictate what rate of return, if any, is applicable to a regulatory asset, correct?
Yes,
And that determination by the commission is outside of this stipulation and this case, correct? If we're talking about a future regulatory asset.
yes. Yes, okay. I would agree with that.
And if you are aware, SPS did not apply any carrying charge or return to the determination of rate case expenses that were to be trued up in this case, correct?
Let me think.
And if you don't know, you don't know.
I'm not sure. I would say I'm not sure.
Okay. And with respect to the reconciliation statement that we have been discussing itself, that doesn't control or dictate anything that the commission or SPS do in the future, other than using the revenue requirement for calculating the rates that have been agreed to in this document, if accepted by the commission, and the other specific provisions of this stipulation, like depreciation, that the parties have agreed to, correct? And that may have been too much in one question.
Yeah, I'm not sure what you're asking.
I will try that again.
Okay, please.
So I think in part of your discussion with hearing examiner Hurst, you were trying to clarify that we do need the bottom line revenue requirement from the stipulation because we need that to feed the rates that are also contained in the stipulation. Is that fair?
I would agree that's fair, yes.
Okay.
Mhm.
But because the revenue requirement is specified to include a black box disallowance, we don't actually need any rate of return or return on equity to set the rates that are specified because they don't actually bear a relationship to each other in the end, correct?
Well, based on all of the previous testimony that has taken place during the week, that seems to be the consensus, that due to the black box amount of almost $15 million, the various components can be changed in various ways to still reach the final revenue requirement. But staff's position is that the stated ROE of 9.35 and the cap structure as stated in the stipulation are what we agreed to.
I see. Let me see if I can restate that correctly. Are you saying then that staff would be comfortable with the 9.35 and the capital structure for use in the calculation, regardless of whether other parties had agreed to that number or not.
That's a fair assessment, yes.
I've got you now. Thank you for that. And those are my questions here in Examiner Hurst. Thank you.
Thank you, Mr. Du Bois. Mr. Bagatko, anything further?
Nothing further, Madam Hearing Examiner. I'm sorry for my connection.
Not a problem. Ms. Ramey, thank you for your appearance, and you are excused.
You're welcome. Thank you. Have a nice weekend.
The same to you. Well, I believe that we have reached the end of our evidentiary portion of our hearing in case number 20-00238. Are there any remaining procedural matters
Madam Hearing Examiner,
that we need to deal with, Mr. Bagatko?
I think there may be some interest in talking a little bit further about what you alluded to earlier regarding briefing and what may be helpful to you in your task to come.
Very well. I don't know whether or not the parties can tell me at this point whether or not they believe there are any legal issues that need to be briefed. I am not no one seems to have disputed and as a matter of fact, staff's in agreement with the company's position on at least my AFUDC question. So I guess I don't see that as an issue that we'd need to have some type of legal briefing on. However, in an effort to try to be more efficient, should the parties want to file proposed findings and conclusions, and or I prefer joint as opposed to separate, although separate would be fine. Proposed findings and conclusions and or a proposed decision. I'm not going to dissuade you from that task. I would ask you by what dates we think that any writings could be accomplished, and whether or not you've discussed that. Don't all talk at once. Mr. Bagatko.
I don't want to hog the floor, but I think we've had some preliminary explorations in that regard. And if anybody disagrees with the time frame I'm about to float, jump right in, please. But I thought, depending on when the transcripts can be readied and in final form, that perhaps we could add something to you in maybe the span of 10 days to maybe around 2 weeks. And like I said, if anybody has any different ideas, please jump in. But I'm just floating that right now.
Actually, this is Joan Drake. I'm just a little concerned that that might be a little short simply because we do have to get the transcript and poor Mr. Lee, he's been so patient with us, but I know he's got a lot of testimony he's got to transcribe. And we are coming up on the PNM merger case hearing in like a week and a half. And I'm sure that's going to take some folks' time. So I'm wondering if we could look at maybe the week of August 16th.
Transcript will be available by next week.
Do you
So do you
know?
want to propose like the 20th? Mr. Du Bois?
Your Honor, I was about to suggest, Your Honor, Mr. Bagacco, a time period of 2 weeks following the final transcript. And we would, if we can file sooner, we'll file sooner. But as a starting point.
Well, and that's approximately the 20th. So if the transcript is all in by next week, by next Friday, that's the 6th. And then if you go 2 weeks from that, that's the 20th. But and then as you say, if you want, always, not many people anymore ever file before the deadline, but obviously that's fine. And it's not necessarily a hard deadline. I mean, if people said, oh, we're working really hard and we really want you to have this and we can't have it before the 24th, I don't think it would be the end of the world, but I don't know. Do you want me to say the 20th? You want me to say the 24th?
You know what Mr. Du Bois and Ms. Drake just talked about would be acceptable to staff, the 20th. We can make that work. Please, anybody else chime in, but I'm willing to dig in and get this done and get something together with everybody by the 20th.
Okay. All right.
Thor Nelson for the NMLCG and the proposal to have a joint submission of whatever brief plus the recommended decision and findings and conclusions is acceptable to us. And certainly the 20th is also acceptable. And we, for our part, appreciate Your Honor's willingness to let the parties sort of put that together to try to help yourself and ultimately the commission as you sort through this.
Absolutely. Okay, well, if I'm not hearing anything else, and again, we'll just put that as a guidance. I won't call it an illustrative date. But sometimes it's nice to have a number to push back against to put things in perspective. And we'll utilize August 20th. And then obviously, if parties need more time, or if somebody wants, I don't know that anyone would file a response, but whatever. I'm just going to put in the 20th right now as a proposed date for any joint or single submissions. And then you all can let me know how that's coming along in context with the rest of your duties and obligations. Mr. Lee, I think I will send you the 2 exhibits, but if, I asked parties to think about and check to make sure all of their exhibits got put in. And I haven't heard anything from anybody else. And I believe we've got through our witnesses. Anything else that we need to deal with? No. Okay, well, thank you all very much. I think I was a little worried we weren't going to get finished this week, but I appreciate people's professionalism, appearing as best they could on time. And I appreciate Mr. Lee and all your hard work. And thank you all. And we are adjourned. Happy weekend.
Thank you.